Record. Okay, so I'm hitting record so that way those of you who are not able to attend live can hear what I'm about to say. So Dr. Helgi and I were talking about y'all all in a good way because we like to compare notes because he looks over, even though he's not grading this week, he kind of likes to look over my feedback to get a good sense of y'all as a group. So that way he knows kind of what to expect because this week the training wheels are off and you guys get to dive into your first true writing assignment. And we'll talk about that here in a second. But you guys are a stellar group. And I say that with all sincerity. Usually we have a good mix of those students who need a little bit more work and those who, are doing really well. And this term, we have more of you who are doing really well than those who are not. Like those who are, when I say not, those who are not doing as well as you probably had hoped are still doing well. So it's I don't know what's in y'all's coffee, but whatever it is, keep it up because y'all are doing awesome. And I don't want to jinx it. Okay, so I'm almost telling myself like, shut up, like don't ruin whatever's happening. But it's really cool to see that you guys are grasping the material as well as you are. So I hope you guys continue to do that. And if and when you guys have questions, please reach out to us, but continue doing what you're doing because you guys are a great group and it's really cool to see the level of thought and application that you guys have been doing. So please keep it up. So that was my really rough way of saying thank you for doing such a good job. So that's it. I just wanted to start off on that really positive note because I want you guys to know that you guys, your work is noticed, your hard work is noticed. And Billy said, Earth has shifted, chocolate my coffee, army style. Ooh, that sounds delicious. You just remind me the other day, somebody gave me German chocolate cake coffee. That was life changing. But this is the bad thing about really good coffee like that is if you don't have access to it, again, it's like, what is life? Like that's it, right? I was really bummed after I had that coffee because I was like, I can't buy it because I don't know where they got it from. So I just had this magical coffee and then that was it. So yeah, that was a good day though. Mm. So with that being said, this week is a big week for y'all, as I think you guys know. We have a lot to cover, but before we do, I do have a few reminders. Okay. I did see a few things I wanted to tackle before we move forward. So, a few of you are still using first person. Don't do it. Remember to use case law. So some of the submissions had great rationale, but not an ounce of case law. And that is weird for legal writing, right? Because when you're writing about a legal issue and you're not using any case law, that would be like a plumber showing up to your house without any tools. That would be weird, right? You'd be a little concerned. And so likewise, you're showing up to my house essentially without any tools when you're submitting analysis without any type of legal foundation. So when you're doing that, in other words, you're just telling me your opinion, which your opinion sounds wonderful, but it's without any foundation whatsoever. So make sure that you guys are using case law. It's your friend. The other thing is when you're referencing the Supreme Court, make sure that you capitalize it. Minor issue, easily fixed. Um, and also, and this is just kind of a strengthening organization tip, try to move your reference to case law toward the front end of your analysis, not the conclusion. So some of you had amazing rationale. So you'd start off saying, yes, blah, 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 blah. And then you'd conclude literally saying, as in Marbury versus Madison. And I'm like, oh no, like push that analysis up, move that case law further on up. Because if you move it up, then I know, and the reader knows right from the start that everything that follows is already supported by case law. And yeah, I say I have a question. Hello. Okay. Well, if you have a question, you're welcome to ask it and either verbally or in the chat, either way. Or if that was an accidental hand raise, that's okay too. Okay. So there is a good rule of thumb that I thought might help. And the rule of thumb is that you state your position first, followed by case law, and then summarize your position. So that's just kind of a good way to structure your analysis. Now, the other thing is, and let me move this so that way you can see what I'm saying here. You need to explain why you're citing the cases that you're including. So a few, not very many, but there was a handful, had case law in your submission, your post, but then you don't say why you're including the cases that you are. So make sure that you, even if it's just one sentence following it, tie your cases to why you feel the way you do, to your argument, right? So if you're including McCulloch, state why you're including McCulloch. Don't just throw McCulloch's name out there, right? So the last thing is watch your grammar and your spelling. There were some minor typos and they're super easy to miss, but they're really important to catch because if you have enough misspellings, enough grammatical issues, then it really does weaken your otherwise fantastic, post. So, with that being said, this week you guys have your first long writing assignment. So the training wheels are officially off. Now, with that being said, Dr. Helgi is grading this week. So if you guys have any specific questions regarding word count or how to apply case law, you might shoot those to Dr. Helgi, but I'm more than happy to help or answer any questions that you have as well. But as always, I did want to give a few long distance high fives to the following post. First, Wanda. Man, Wanda hit it out of the ballpark. So she rocked this last week, and in particular, I think you can see why. She said judicial review keeps the branches in balance by allowing the Supreme Court to invalidate laws or executive actions that violate the Constitution but cannot compel another branch to act. Marbury versus Madison. And then she continues. Now, yes, she did go over the word count, and that was something that I believe I told her in my feedback. But what I want to point out is that her rationale was strong. She states exactly what she believes very clearly. Now, that's something that some of you need to work on is expressing your why. So make sure that you express your why clearly. Secondly, Sarah Tate rocked. She states from the beginning not only her position, but she ties her position to a reference, which is beautifully done. So Sarah, great job. Um, Now Brian asked, is case law inclusive of congressional acts or only after they are challenged or affirmed by the Supreme Court? Is case law inclusive of When you say is case law inclusive of congressional acts or only after they are challenged, affirmed by the Supreme Court, that's only after if they're brought before the Supreme Court, Brian. So if they're brought before or challenged by the Supreme Court, that's only how they become case law. So if we go over it in class, then you can use it, and that's how it becomes, inclusive of the category that we're talking about. Does that make sense?
It does, thank you. Let me just to confirm, like, if you're referencing the Civil Rights Act of 1964, is it sufficient to reference the act, or do you need to reference the cases that affirmed it? Because that's where I'm a little confused. Like, normally you see a lot of texts that just talk about the Civil Rights Act, not specifically how it was challenged or not challenged.
Great questions. The only way that we want you bringing up the act is if it was discussed in one of the cases that we cover.
Okay, great. Thank you. That's super helpful.
Yeah, absolutely. And then Billy just included a German chocolate cake coffee recipe, I believe, which is amazing. So thank you for including that. And I'm actually very excited to click on that here in a second. So Sarah's, as I want to emphasize, states her position from the outset and she ties it together beautifully with a reference. Whitney Isbell, same thing, concise, ties her position from the very beginning to a case law reference, which I think is beautifully done. Kenneth, wow, just awesome, concise writing that ties together beautifully with case law. Again, I hope you guys see the theme that their positions are consistently tied together with case law. So, again, I want you to notice this pattern that I'm emphasizing from each of these long distance high fives. And then honorable mentions and long distance high fives also go to Aya and Owen. So if I didn't mention you, it doesn't mean that you didn't do awesome. But again, we have a massive amount of you this term, but these are the ones that I was able to pull from and that stood out this last week. So keep trying hard so you guys can also be mentioned in the upcoming long distance high fives. All right, so this week, you guys actually have some options that Dr. Helgi wanted me to bring up to y'all. So you guys can write in the same way that you guys have been writing. So if you enjoy writing in the way that you have been, then keep doing that. Meaning, if you like writing in the way that you answer the question, yes or no, followed by your why, and including your legal references like your case law, your Fed paper number 78, and then re-entering your position, that's great. Okay. That is okay. That's paragraph form. Okay. Or you can write what's it called IRAC style. So don't scream into the hills yet. Okay. Again, this is an option. You do not have to write in this format. It is an option. And I feel like many of y'all feel like probably Scooby-Doo at this point. So if you don't know what IRAC stands for, it is a format in which a lot of law schools teach their law students to write in. Darn it, I'm trying to move this bar. There we go. Go up this way. Oh, it's not doing it. Okay, there we go. And it means that you state the issue first. And by that, I mean you literally write issue, colon, and then you state the issue of the case, meaning what is the court faced with? What question is the court being asked to answer? And then state second, rule. And you literally write the word rule, colon, and I'll go into an example of what these look like. And then you go into the analysis. And then the conclusion. What did the court rule? So I included this link right here, lawschoolsurvival.org, with an example outline of an IRAC. So the other thing I want to point out is if you have looked at oye.org or .com that I've encouraged you all to go to look up these cases, on the right-hand side, it gives a breakdown of the case. Guess what style that is? That's IRAC. So when you guys go to that link to look up cases, it actually gives you the issue, the rule, the analysis of the court, and the conclusion, meaning how did they rule? What was the holding of the case? And let me see. And I see, there's somebody had left a hand up, but I just saw, I think, a hand raise. So if I did see hand raise, go ahead. Mm-hmm. Billy? Okay, well, if you do have a question, you're welcome to ask it. And then I see, well, I see that there's another hand raised as well. Because somebody said, I think your hand is raised, and that might be the case. I'll lower my hand, but I see Billy's hand is raised as well. Thank you for pointing that out, by the way. I ask myself questions often. Oh, that's okay, Billy. See, Billy, maybe it's that German chocolate cake recipe and that's in our heads and it made us raise our hands. Okay. So this is also a breakdown of what that looks like. So again, this is an option. You by no means have to write in this format, but Dr. Helgi said if you like this kind of rigid structure and it helps you kind of stay in your lane mentally and helps you write, then this is a good option. Some people like this kind of structured outline style as they go over their responses. So if you like it, that's great. The other thing I want to point out for those of you who have trouble identifying mistakes in your writing is Grammarly. I use this every day. It's awesome and it's free. There is a paid version, but honestly, you don't have to pay for it because it's not all that much better. And you can get it as a plugin. It plugs into Safari or Google Chrome as an extension. It's great because it identifies if you have something that's misspelled, if you have something that needs to be tweaked, all that fun stuff. I would definitely go for it if you need something of that. Sorry, I didn't mean to do that. Of that nature, then you can go to grammarly.com, plug it in, and it's fantastic to identify if you have any other issues. Now, if you go to Oyez, there is something somebody asked me the other day that I wanted to point out that some of you might also have questions about, which is you have an option. It says case versus summary. Use the option for case. Do not use the option for summary. You want the whole enchilada, not just summary. Okay. Now you can use summary if you just want a quick overview, but I would encourage you guys to read the entire thing. And this is what your whole entire assignment looks like for this week's full written assignment. Now, with that being said, guys, you do not have to, when I say this, you guys don't have to, at the very bottom, go at this in one take. What I would suggest is to go over this, read it, walk away, and then come back to it later. Okay. Don't try to tackle this in one sitting. Now, before I go any further, does anybody have any questions about this? If you've tried to tackle this already? I see Angela, did you raise your hand?
I did. I don't have a question about this necessarily, but I did have a question about using Grammarly and other um, spell check systems. So
Sure.
I'm coming from another university that we were required to do our work in Canvas. Um, a, you couldn't do your work in Word and then copy and paste it in, essentially. So that's not the case here, though. Is that correct?
No, no. In fact,
Okay.
we actually encourage you to do the opposite. So Dr. Helgi and I, do not forbid you working in Word at all. In fact, I encourage you, and so does Dr. Helgi, to work in Word, because that way, Canvas doesn't catch typos very well, if at all, I don't think. Whereas Word does. And so I encourage you to go to Microsoft Word or whatever platform you're on if you use a different platform, but Word is usually the most common. Work on it, outline it, run it through Grammarly to catch anything that you need to. What we don't want to see, and I think this is common sense, is for any of you to run it through ChatGPT and let it write it for you, or to copy and paste it from those type of platforms. That is no, of course. But it
Yes.
is
Okay.
okay, to use it to brainstorm, to outline, that's okay. So, there are structures in place, but Grammarly is great to use to catch typos, misspellings, that kind of thing. Does that make sense?
Yes, that is so helpful. Thank you.
Absolutely. And Billy said, is that the same with tests? It is. It is. In fact, I'm glad you asked that, Billy, because the final will actually look very similar to this. The final is not multiple choice, it's not true and false or any of that. It actually is a hypothetical that is in this type of format. You'll have the whole week to do it, just like this, and you'll be asked to apply case law again, just like you're being asked to this week. So it's a different hypothetical. It's not this one. But same structure, same kind of vibe, right? So this is a good training ground for you to kind of understand what and how you'll be tasked to tackle the assignment for the final. Does that make sense? I'm kind of giving y'all a sneak peek, so to speak. All right. So This week, and I say this every week, guys, and I know you guys are going to get sick of me saying this, but this week is full of some stellar cases. Now, there's one case I'm not going to go over just for lecture's sake, which is Carson. Is it Carson B. Macon or Kennedy? I can't remember which one. There's one that I cut for time's sake, and I guess I'll find out in a second because I did it 2 nights ago. I was going through it and kind of timing myself because that's what I do. And so I cut it for timing's sake. But irregardless, you should go over it because it's on the list of required readings for this week. But I will ensure that you understand the idea, the legal concepts that are instilled within each of these cases. So, without further ado, let's talk a little bit about the First Amendment. So, in terms of context, let's just read it together, okay? So Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So that's a whole lot of stuff, right? But there's some things to note about the Bill of Rights, which is when the original Constitution was in place, our founding fathers were smart cookies. However, they didn't include it in the original Bill of Rights. In fact, it wasn't even a twinkle in their eyes. The original Bill of Rights didn't say anything about the establish religion, prohibit establish religion, or exercise religion, Second Amendment, Third Amendment, Fourth, Fifth, Sixth, Seventh, Eighth, Ninth, Tenth. It didn't say any of those. In fact, the original Constitution only had the original articles, right? The preamble, and that was it. And so it wasn't until the founders, the delegates, went out in order to get it ratified that there are a few rumblings that said, there's something missing and we're not okay with this lack of attention on us. And so we want you to come back in 3 years and say a little something about us. And luckily they did. And had they not done that, though, arguably we'd still be bowing to a king. So it wasn't until 1791 that they came back with this beautiful, beautiful Bill of Rights. And so some things to know moving forward. And I do have a chat. I'm glad you enjoy the Mr. Rogers slide. So I want you guys to read this with me. St. Mary's University, a private university, bans students from wearing the color red in their classes on Fridays. A student argues this violates their First Amendment right because she is an artist and wearing specific colors daily is an expression of her art. Can the school prohibit a student from wearing red in their classes on Fridays? Tag, y'all are it. What do y'all think?
Yes.
Any other thoughts? Okay, so Ignacio, Dan, you both said yes. And so now I want to follow up with a why.
I mean, it's a written policy within the university, so they have to adhere to those policies.
Okay, good. And the one thing, though, that Dan hit on that's extremely important is Dan said private school, not a federal government overreach. And then so did, yep, okay, you guys hit it on the nail head. It's a private university. Nothing in the Bill of Rights applies to a private entity. And I'm going to emphasize that even more. It does not apply. So, one thing to kind of keep in mind when you guys read the hypothetical is, are you dealing with a private entity or a public entity? Okay, that matters because the founders were not concerned with private actors. They were concerned with federal actors, right? They were concerned with the government, not Tim or Bob, right? They were concerned with government actor Tim or Bob. So that's the first thing you should be asking is who are the actors? Are they working for the government? Are they federal actors? Are they state actors? That matters, okay? What hat are they wearing? So Ba-ba-ba-bum. Let me move my face. That way you guys can see this. So would your answer be the same if I change that to Tamu?
Does it get federal funding? If the answer is yes, then they don't have the right to prohibit the wearing of that red color.
Okay, so I see some no, and Ignacio said it had to be federal. Does it have to be federal?
Can it just be
State
government
fund, yeah,
that
state
receives
funding.
the federal
State
funding?
or federal.
Okay, good, good. So I see you guys are expanding your umbrellas, which is a beautiful thing. So it's not just federal now, it's state too. So Ignacio, it was Ignacio originally said federal, right?
Yes, I said federal.
Yes.
Okay, good. All right, so you weren't initially wrong. So you're right. Initially, the original Bill of Rights, 1 through 10, didn't apply to state actors. So you're not originally wrong. The original Bill of Rights, 1 through 10, only applied to federal action because the founders, they weren't concerned with state actors. They were concerned with, again, we don't want another king. So they were concerned with federal action overreaching and hurting us, we the people, right? So that's why they put the original Bill of Rights. And if you look at the Fifth Amendment, it says the government can't take away one's life, liberty, or property without due process of law. Where else do we see that? Because it's so important, it's so fundamental to our country that it's not just in our Constitution once, it's in it twice. Where else is that statement?
14th Amendment?
Bingo. So after the Civil War, the South wasn't very happy, right? And so, in order to calm them down, but also to make them behave, we had to put in the 14th Amendment. So then we added two words: no state, right? No state can take away a person's life, liberty, or property without due process of law. So that's where we took it one step further. So that's why I say the answer would be different if it was Tamu, because we're a state actor, right? So that takes it a step further. So it can be federal or state action now. Does that make sense? So that's called selective incorporation, meaning the Supreme Court can say, Texas, you can't do it either. So it's not just the United States as a whole, right? Meaning federal action. Now they can take the leash, put it on Texas or whatever state it is, and make them fall in line too. So it's federal and state action.
What'd you call it, ma'am?
Selective incorporation. Selective incorporation, meaning that the Supreme Court over time has selectively incorporated almost, and notice I'm saying almost every single one of the Bill of Rights, meaning they've made the states fall in line, put it under the umbrella, saying you state can't violate a person's First Amendment right. You state of Texas, you have to respect a person's Fourth Amendment rights as well, and Fifth Amendment rights. There's only, I'm making sure I'm correct when I'm saying this. I would say, yeah, there's only about one Bill of Rights that has not been selectively incorporated. Does anybody know what it is? It's the right to a grand jury. Some states have grand juries and some don't. Anybody know what Texas has? Does Texas have a grand jury or no?
Texas
Yeah.
has a grand jury
That's
system.
right. Absolutely. And some don't. So that has not been selectively incorporated, meaning some states have them, some states don't. So that's about it. Otherwise, most of the Bill of Rights have been selectively incorporated. So before I move any further, does anybody have any questions? Because I know that can be a lot to digest. All right. So this is one of my favorites because, like many things, there's some interesting background with the First Amendment. So essentially, it protects religion, speech, and the right to protest, assembly, to get together, right? But today we're going to focus on the first. And to kind of simplify things, the religion aspect, that prong, it protects what I call the two E's, right? Which is establishment and exercise. Now, remember our good friend TJ? Do you remember who TJ was, guys?
Thomas Jefferson.
That's right. Good old TJ, Thomas Jefferson. So I am positive, I'd be willing to bet that every single person in this room has heard the statement that there is a separation between church and state. But is it anywhere in our United States Constitution?
No.
No, you're right. It's nowhere in there. So where that statement actually comes from is good old TJ. And the reason why we have it today is that many, many years ago, when he first, of course, came into his presidency, and he was already mad at his cousin, remember John Marshall, and we had Marbury versus Madison, he got into a fight with the Baptist. So the Baptists wrote him a letter, and they were mad at good old TJ because he was being requested initially to make into national holidays certain specific dates that they felt should be recognized as national holidays. And if you ask me what they were, I don't know. I should look into that because I have been asked that before and I don't know off the top of my head. But they had asked him for specific dates, and he was so mad about that. And the reason he was mad is because he initially ignored their letter, and they followed up, and they kind of chastised him about it, saying, shame on you. You have a right, you have a responsibility, nay, a duty to respond to us. And he was incensed because, as one knows, TJ had a little bit of a temper. So he responded in kind, and he said, shame on y'all. And he said, not only do I not have a duty to respond to y'all and make this into any type of national holiday, nay, in fact, under the First Amendment, there's a separation between church and state. That is the first time in which our national discourse had even heard that sentiment, but absorbed it into kind of our conversation, right? Our belief system. So much so that it was from that point that his cousin, John Marshall, he read that and probably thought that's a good point. And he later used it in a subsequent case. And so it started to become part of not only our discourse, but our belief system. So that is where we see, and if you go back to the First Amendment, here we go. Congress shall make no law respecting an establishment of religion, meaning not only can the United States not create a religion, but also taking a step further, they can't make you practice one either. And this is Dr. Shaw, this isn't the law, but I call it the UBU, meaning they can't tell you what to do. So if you want to practice whatever religion you want to practice, that's fine. So I see I have a question. I think you're muted.
The holidays were National Fast and Thanksgiving.
Oh, thank you. Oh, one of them, right? So that's
Correct.
interesting. Thank you for looking that up.
But they would have forced us to not be able to eat on certain days.
Well, that's not good. I never enjoy days I cannot eat. That's interesting. Thank you for looking that up. So, all in all, excuse me, when we look at that, we have these two funnel belief systems. On the one hand, our government cannot establish a national religion. We cannot say tomorrow, everybody has to be Scientologist, right? Can't do that. On the other hand, if you want to be one, we can't stop you from doing that either, right? So it's an interesting weight that our government has to consider, right? So how many of you have seen this picture? And it's one of my favorites because she kind of has like crazy eyes, right?
Is that a colander on her head?
Okay, I am very happy that you use that word because when I first started teaching this specific case, my husband used the word strainer, and I had to tell him no, it's a colander, and he was like, no, it's a strain. And so we got into this like tit for tat, and he's like,
They're different.
Callie, he's like, you're not 90, and I was like, no, I'm. It doesn't have to be. It is a colander. So you just really made my heart so happy by using the proper terminology.
Well, good.
Okay, so without further ado, I want to introduce you to Miss Miller. Miss Miller is a proud member of the Church of the Flying Spaghetti Monster, which, if you have not heard of this church, they started in the early 2000s as a tongue-in-cheek group that believed in advocating more for science. And they said, who are we to say that the God is not a flying spaghetti monster, right? And one of the things that they did as a sign of being a part of this church is they would wear a colander on their head. And yes, a colander. So when she went to take her driver's license photo, she put this on her head. I would have loved to have been there to see the DMV employee's face when she put this on her head, because I can imagine that he or she was like, why did this have to happen on my shift? But nonetheless, the DMV employee told her no. And she told the DMV employee, I have a right to wear this on my head. It is my religious belief. She was told to leave, and she was refused the ability to wear this initially. So she sued because they would refuse to allow her to do this. And that makes my day that you had the same conversation with your husband regarding the colander and strainer. This is like, I guess this is a thing. So she was refused to allow to wear this, and she was actually escorted by police out of the DMV. And this case made it all the way up to the state Supreme Court in Massachusetts. Now, when it reached up to the state Supreme Court, the question was, does she have the right to exercise this religious belief? Now, the court determined that yes, she does, as long as it does not violate any criminal or procedural or ordinance regarding a driver's license. Now, what is the one requirement in any driver's license photo? You must be able to see a person's what?
Eyes?
Face.
Their face. Can you see her face?
Well, sort of.
Yeah, you can see her face. Hold on one second. My dog got stuck. Hold on one sec. Sorry about that. He's 20, so he gets stuck fairly easy now, guys. Sorry about that. Hold on, buddy. There you go. All right. So, with that being said, you can see her face. And so, a lot of people, this raised a big stink because there is a series of cases right now that I usually don't hedge bets legally, but I'd be willing to bet that we are, within the next probably 6 to 7 years, going to see these cases go higher in the court system because there is a group of women in Mississippi that have sued because they have been denied the ability to wear their religious garment, which is the burqa, and their photos. But what is the difference between that? And for those of you who may not be familiar with that religious garment, it covers the entire face, except for this section right here, the eyes. What might be the difference, arguably, between that and this? Well, arguably,
Just the amount of face coverage.
correct. The amount of face coverage. Here you can see her entire face, except maybe the top part of her forehead, versus the full burqa, which prevents you from seeing the full face and only the eyes, right? So, in that, the ordinance, the requirement, the policy in a driver's license photo is one has to see one's face. That might be the argument against that. So it'll be interesting to see how that one plays out as it moves forward. So we'll see how that one goes. But nonetheless, you do have rights under the Bill of Rights, but, and I want everybody's ears to perk up when I say this, no right is absolute. No right is absolute. You do have a First Amendment right, but you don't have the First Amendment right to say whatever you want or to practice it whatever way you want. There are always limits to whatever right is at issue. And that brings me to this case.
Jacobson versus Massachusetts.
There we go. And Dan said, what's the point of a state ID if you can't use it to identify the holder? And that's a good question, Dan. That's a good question. And I think that's going to be one of the arguments within that case. If it gets higher, I could be wrong. They may not reach higher, but I have a feeling it might. All right. So for those of you who have not had an opportunity yet to read this case, I'll hide my face so you guys can see the details. But in Kennedy versus Bremerton, a fairly recent case, but we have the overarching issue is a coach who is praying with football player and students after games. Now, if you look at the details, and I'm really, really summarizing here, we have Coach Kennedy who would take a knee on the field, usually by himself, and initially he would say a quiet prayer. At first, he kept it private. However, some students started to notice and they asked if they could join him. So sometimes the players, whether they were on his team or the other team, would join him after the game to pray, but it wasn't part of the game school. So the school said to stop. Now, it's important to note that the school said to stop because they were really starting to get nervous. They're a public school. So why do you think the school was getting nervous?
The
Anybody?
establishment clause, because he was allowed to pray. They wanted not to
That's right.
be fostering a religious sect or organized practice.
That's right. Exactly. So the separation between church and state. They didn't want to appear as if they were endorsing or establishing any type of religious belief system, or making the students feel like they had to engage in that in order to be a part of the team, right? So they didn't want to get sued. So they told him to stop, and he did not. So he was suspended. He wasn't fired. He was suspended initially, because of the liability associated with his conduct. So the issue before the United States Supreme Court is a public school employee's prayer during school sports activities protected speech? And if so, can the public school employer prohibit it to avoid violating the Establishment Clause? Now, they initially held, their holding was that the Constitution neither mandates nor permits the government to suppress such religious expression. And the million-dollar question, guys, was why? Why did they permit this? So the ultimate thing that it fell on, in a nutshell, was timing. So when did he hold the prayers? Did y'all, those of you who had read it, when did
After
he
the
hold
game.
And why
That's not
did that
his
matter?
that's not his job as a
Mm,
coach. That's his own personal time because he coached the game and did that after the game, and the school district hired him to coach.
good, excellent. And what were some of the analogies like that they gave in the opinion where they said, well, he would be doing XYZ during this same time period?
Oh,
Did anybody catch that? Because it was really interesting. So they said during this time period, he's free to do other things like make phone calls, answer texts, go to the bathroom. In other words, they're saying this is his time. He can do whatever the heck he wants during this time. So when it's your time, you are free to be you. And remember, under the double E of the First Amendment, the government can establish religion, but what else does it allow you to do? What's that second E?
exercise.
Bingo. So it can't make you practice a religion, but it can't stop you from exercising your own. So there's also that other E. So there's double E. You can't establish a religion. Remember good old TJ, separation of church and state, but it can't stop you from doing yours. And so they were arguing that this wasn't during that public employee time period. This was during his free time. the time that, again, he could use the bathroom, answer texts, do his own thing. And when it's on his time, that is his time to be himself. That's the you be you time, in other words, right? So before I go any further, I want to make sure that y'all understand that. Did that make sense before I go any further? Because I simplified that quite a bit. And Dan said, and on school grounds, public. Yes, okay. If any of that needed clarification, let me know, because now we're changing gears big time. So we went to the First Amendment, and now we're literally doing like a 180 into a totally different sector. And this is what I really want to devote the rest of this time period to, because it is a big concept. So now we're getting into interstate versus intrastate. And this case, it may be from 1942, guys, but it as of 2026, it is one of the most hated cases in I would say legal history. People hate this case. Even today, 2026, this case in law schools make people scream. If you Google law review articles, there are students this year, I guarantee, that will pick this case to write about, and they will be writing clear hate notes about this case. And you may, after I walk through it with you, feel the same. Or you may take the other side and think, I understand the rationale. So without further ado, are you guys ready to learn about one of the most hated cases in Supreme Court history? So let's just get into it. So one way to remember this case is, I always like to say Wickard Wheat. And it's an interesting case because we're dealing with a farmer. And it's time period wise, we're coming out of the Great Depression. Our economy is not great, right? And so people are scrambling. They're trying to improve things. So let me hide my face so you guys can see what I'm talking about here. So we have the New Deal, and they implement what's called AAA, which is not the car thing. It stood for Agricultural Adjustment Act. And during that time period, they actually put a quota on how much farmers could grow. So just kind of wrap your head around that. But there was a method to their madness. They had, at that time, a whole lot of wheat. And just pause. For those of you who are business savvy, why would having a ton of wheat be a bad thing?
Well, it wouldn't necessarily be a bad thing, but too much wheat could drive down the price.
That's exactly right. The farmers are going to make a lot of money, and the economic climate isn't going to get much better, because if you have too much of something, it's going to drive the cost down, which is good for people in the short term, but bad in order to, yes, if you flood, and Kaylin got it. She said, if you flood the market, drops prices, price, good. Okay, so they're trying to get things on track. So Philborn, and there's the farmer, he grows wheat. And poor Philborn, he is growing for his own home consumption and for his livestock. So he has cattle, he's growing it for them, he's growing it for his family. And he's actually fined, guys, for growing over the max amount. Now, I want to emphasize something. He is not growing the wheat for selling it to the store so that you and I could buy it. He's growing it for himself and his livestock. But because he grew over the max amount, he is fined. So he filed a lawsuit against Wickard, who at the time was the Secretary of Agriculture. Again, he didn't put it in the stream of commerce. This was for his personal use. So the $1 million question is, can they regulate, and by they, the federal government, can they regulate in-state activity? Now pause. Do y'all remember, and this is a big pop quiz, last time we chatted last week, we talked about a very specific act that allowed the government to regulate activity. What act did we discuss? Y'all remember?
The Commerce Clause?
Good. And does anybody remember what article that was? And I'll give you a hint. We were talking about good old Ogden. Okay, I'll give anybody who
Isn't
finds
that
that.
Article 1, Section 8?
Good. Excellent. Article 1, Section 8. And Megan got that too. So yay, that's exactly right. Article 1, Section 8. So in it, it gives the government the ability to regulate interstate commerce, interstate. And remember, that's commerce that goes across state lines. Here, we're not talking about anything that crossed any state lines. Filburn didn't cross state lines. He's on his cute little farm, right? But nonetheless, they're saying, you, Filburn, you're growing above the max amount, so we're going to fine you. But here, the court said, well, we're going to allow this because we're going to allow this regulation as long as it has a substantial effect on interstate commerce. Now, I really want your ears to perk up when I say that. They're allowing the government to regulate in-state activity, even though it doesn't cross over state lines, as long as it could have a substantial effect on interstate commerce. And here they're saying, well, wheat grown for home consumption could have an effect on interstate commerce. The economy could turn for the worse again, and Filburn may be tempted to sell on the open market. Now, consider that for a second. They're saying if we go through another Great Depression, Filburn could do a very human thing. He could, instead of growing the wheat for himself and for his livestock, he could go into town, sell it to, put it on the market to go sell to Alabama, to Mississippi, to wherever, in order to put food on the table, right? Again, that's a very human thing to do. You want to survive. The Great Depression was horrific. And so they're saying because of that fear, because of that what if, that could have a substantial effect on interstate commerce. So forcing Filburn to purchase on the market could improve the market. And for those of you who are visual learners, I found this graphic, which I thought was pretty good. They're saying that as long as activity could have a substantial effect on interstate commerce, that the government can regulate it. And where you see this it says aggregation principle. Think about this. Yes, there's just one Filburn. And poor farmer Filburn, you got to feel bad for the guy, right? And his action alone may not seem like a big deal. But they're saying it's not just farmer Filburn, is it? There could be 1,000 farmer Filburns. And again, what if there's another Great Depression and they all do the same thing? Consider that impact. That would be a massive impact. And so in order to avoid that, we've got to be allowed to regulate that intrastate activity, meaning that activity that, yes, it may not exit state lines, but nonetheless, it could still have a mighty effect on interstate activity. And then now we get to Morton Ralston. So how many of you were able to read this case?
I didn't think we had that case. Oh, Heart of Atlanta Hotel, yes. Yes.
Okay. So this case, even though it took place so long ago, its ramifications lasted for decades. Morton Ralston, he must have been an interesting fellow in person. Now, what he's standing in front of, and this is an actual picture of Morton, was the hotel/diner that he owned and operated. And this is where it all began. 2 hours after the Civil Rights Act was signed into law, Ralston files a lawsuit for $11 million. And he said that the law was unconstitutional for two reasons. The first reason, he said, was that it violated the Fifth Amendment, which states, nor shall private property be taken for public use without just compensation. The second, he argued, was that it went beyond the jurisdiction of Congress to regulate commerce within a state. Now, I'm going to pause for just a second. As soon as the Civil Rights Act was signed into law, he actually came out with this news conference, and it was a big deal. He had this news release. It was videoed. There's YouTube videos of it. I would have shown it to y'all, but if I show it to y'all and I post this video on YouTube like I usually do, they'll kick it off for copyright purposes. But I strongly recommend that you guys YouTube it because it's fascinating to watch just this historical canister moment in time, because it was literally, I mean, he was ready. As soon as they signed it into law, he came out with this. And it's fascinating because the court, what you can tell, they were not happy campers with his first argument. Now, pause for a second. Why do you think that they were mighty unhappy with his first argument? Why did they strike it down so fast? Because think about what they're saying. What they're saying, and by there, I'm saying Morton Rolston and his attorneys, is that by requiring him to allow African Americans to come to his hotel, that they're taking away his business. That's what he's arguing under the Fifth Amendment. Because read the Fifth Amendment again. Nor shall private property be taken for public use without just compensation. He's saying that by requiring him to allow African Americans to stay at his hotel, that the government has taken away his private property without giving him money. So why do you think the government struck that argument down?
Because they were still paying for the services. He was getting compensated from the patrons. He was just trying to find a loophole to say that because the government was forcing him to allow them to stay, that it was like commandeering his resources.
Good.
Yeah, it wasn't free. It wasn't free. I mean,
Excellent. Both of you are right on target. And I want to take it even one step further. Not only were they paying, but now he was actually getting more customers, right? So the government's like, not only are they paying customers, but now you're getting more customers, Morton, you Yahoo. So they struck that argument down really fast. Now, the real impetus of this lawsuit was on his second argument, which was that it went beyond the jurisdiction of Congress to regulate commerce within a state. And this is important because when you look at the 1964 Civil Rights Act, it was not passed on the 14th Amendment, which a lot of people assume. It was not. Instead, it was passed on the Commerce Clause. Now, many people kind of have a Scooby-Doo moment when they realize that, meaning the government passed the Civil Rights Act based on the ability of Congress to regulate activity that occurs between states, commerce that occurs between states, interstate commerce. So the issue before the court when this case arose was, did Congress, in passing Title II of the 1964 Civil Rights Act, exceed its Commerce Clause powers by depriving places of public accommodation of the right to choose their own customers? Now, the Commerce Clause, it extended the anti-discrimination provisions in the Civil Rights Act to hotels that host travelers from outside the state. The court held the government could enjoin the motel from discriminating on the basis of race under the Commerce Clause. The million-dollar question, guys, was why? Now, as a side note, I linked the case here. So for those of you who haven't had a chance to read it, you can read it through this link, but I highly encourage you guys to listen to the oral arguments because, again, it is a snapshot in time, and it's just fascinating to hear the questions and the arguments for and against by the state and by Morton's position. Is just fascinating. But here's a few initial details. The motel was readily accessible to the interstate. I mean, that is why he literally chose this spot. Now, why do you think he chose this spot?
Highly trafficked area. You're gonna
Exactly.
get a lot of business.
And that's exactly why he chose it. He wanted customers from the interstate to not only see his motel, but to stop on their way. Now, what is the point of, or what is the typical person who is traveling on the highway? Where are they coming from?
Another state.
Bingo. They're coming from out of state, which in and of itself rings the bell of interstate commerce. But even taking it from an even further level, he actually solicited patronage from outside the state. He had national advertising media, including magazines. He had billboards. In fact, he had over 50 that solicited patronage to his motel. And he accepted convention trade from outside Georgia, and approximately 75% of its registered guests were from out of state. So, I mean, it was just screaming interstate commerce. There's nothing about his motel that was intrastate, like he was trying to argue. And that prior to the passage of the act, the motel, of course, excuse me, had refused to rent rooms to African Americans and alleged it intended to continue doing so. And he was pretty firm with that. In fact, this front part, this diner, was pretty infamous for kicking out African Americans during sit-ins. In fact, there is a story about that here in a second that I'm going to tell you that is pretty incredible. But going back to the interstate commerce, remember, is the ability to regulate local incidents of commerce that have a substantial relation to the interstate flow of goods, thanks to what case? What?
Ogden.
And Wickard Wheat, right?
Wheat guy.
Yep. I like how you say that, the wheat guy. That's exactly right. So we have Wickard Wheat, which opened that door to allow the government to regulate purely intrastate activity as well. And there's a reason why I'm bringing that up. So just kind of keep that tucked away. So the court, when they looked at that, they said the act does not violate the motel's due process rights for two reasons. And the first one we already talked about, they knocked down real quick, and they chastised the lawyers. If you listen to the oral argument, they were pretty upset with the attorneys for even raising that as an issue. But the second, they said the 14th Amendment was adopted to prohibit discrimination, not to support it. And the justices, they walked through this with excruciating detail because each of them had something to say about it. So you have quite a bit of concurring opinions to go through, and I hope that you guys do go through them. But Douglas and Goldberg, they said an impact on interstate commerce should not have been a prerequisite for receiving protection against discrimination. So what you're seeing here is Douglas and Goldberg, they're kind of upset with Congress. They're saying, why did you go through the interstate commerce clause when you should have gone through the 14th Amendment? Now, why do you guys think that Congress went through the interstate commerce clause to get the title passed and not the 14th Amendment? What was the reason for that, you think?
They crossing state lines and universal across all, Congress making a law that's for the good of all, where federal hierarchy steps in over state.
Oh, see, that's a good point. I like that.
But yeah, they had more evidence regarding the interstate rather than anything else.
And when you say evidence, what are you thinking of?
Well, like you have.
And so one thing I want you guys to think about is just to kind of keep it even more simple. Do you think Congress, and think about that time period, could they have passed it under the 14th?
They wouldn't have received the votes to pass it by law, the 2/3. So that's why they went through the commerce.
Yep. And then, so I'm glad you said it like that, because during that time period, this was such a hotbed of controversy. that they were barely able to get it squeaked by using the Interstate Commerce Clause. And so it was one of the few ways that they could even get it passed was using the Interstate Commerce Clause. It was just their ability, it was I don't want to say the easiest, but it was one of the only ways they were going to get it through was to get it through using the money avenue as opposed to the race category, the equal protection category under the 14th. Because had they used the 14th, the Southern-based congressional representatives just were going to fight it tooth and nail. As opposed to using the Interstate Commerce Clause, it was just less controversial. And so that was one of the arguments, though, that Douglas and Goldberg were saying was they thought they should have gone through the 14th. And Congress are saying we would have, but it would never have passed. So it's an interesting conversation that they're having. And that's what I want you guys to recognize is this is what you're seeing here is the Supreme Court and Congress basically having a conversation with each other, which is kind of an interesting side note. So Douglas and Goldberg, they're telling Congress, you actually had stronger authority under Section 5 of the 14th Amendment, the power to enforce right of all persons under the equal protection law. But Goldberg, what Goldberg is saying, which is kind of interesting, is that, look, you could have done it under both. I understand why you did it under the Interstate Commerce Clause, but I also think you should have done it under the 14th Amendment as well. So they're saying it didn't have to be either or, you should have done both. Now, Mr. Black, who is, of course, concurring, and this is where your ears should perk up, because this is where, remember when I told you Wickard wheat is kind of coming back here? So Wickard wheat is coming back here because it wasn't just the Heart of Atlanta in this case. There's also in this case another plaintiff, and it was called Ollie's Barbecue. Now, Ollie's Barbecue was a little different than Heart of Atlanta. Now, they were merged into the action, and they served arguably a few out-of-state travelers, but they bought food to serve traveled interstate, sorry. And that's where the court said, because you bought food to serve interstate, and they counted napkins, they talked about forks, that type of stuff, that it was those items that opened the door to regulation. And so the motel, excuse me, said that as substantial buying power of goods and if discrimination was allowed, then it could disrupt the flow of interstate commerce on a wide scale. Now, Goldberg's concurrence is interesting because they said the focus should be not only on economic harm, but also moral harm. The greater level of humiliation. The right under the 14th Amendment to life, liberty, property, insulates ability to travel, be happy, free of discriminatory practices. And so these two aspects of the case stand out in legal law reviews because people have had an issue with the door that Ollie's Barbecue arguably opened because it said the argument was it was kind of an extension of Wickard wheat. And so I just wanted to bring that up to y'all in terms of, did it have a substantial effect on interstate commerce, right? And I want to also bring up the fact that if you look around you now, and I'm looking around me now, surrounded by, again, 5,000 boxes of Girl Scout cookies, and very few things that we have today, if anything, are made within one state, made within one country, right? And so think about how much that allows our government to regulate. It's pretty much everything today, arguably. Now, whether that's a good or bad thing, I'm not saying my opinion on that at all. I really am not, I don't have a horse in that race. I'm just pointing out that based on that rationale, that opens a lot of quite a big door to regulation based on that rationale. So just kind of as food for thought, so to speak. Now, I promised y'all that I had a fun fact about that case, and I'm coming through with it. So Morton Ralston, he never quit. He hated the fact that he lost, because he did in fact lose, of course. And he had a 17-acre private property, And he actually had a clause that he included on that property that people of African descent were not allowed to stay there, and added that if it was ever sold, the clause would have to remain in place, if you can believe that. Well, because he had to claim bankruptcy, the property was auctioned off, and it was auctioned off to none other than dun dun dun, dun Tyler Perry. And he actually demolished the initial property. Rolston was jailed for contempt, not to mention a bill of peace requiring him to stop filing lawsuits and being threatened with disbarment, because he actually later became an attorney. Now, it gets better. Congressman John Lewis, who has since passed away, he was actually in attendance at a party held by Tyler Perry, and he stated, "I was one of the young men that sat in at his lunch counter trying to integrate, and here I am dancing on the property that he once owned." Isn't that cool? So just kind of a full circle moment. I just thought that was a pretty cool, yeah, exactly. Definitely poetic justice. Now, I'm sorry I'm going a little bit over, but I did want to share that story with y'all. So this case is definitely an interesting one in terms of timing, and I'm going to bring up why that is so here in a second. So this case occurred in San Antonio, Texas, of course, but it's 1995. A 12th grade student brings a gun to school. Now, the next day, the state of Texas charges were dismissed after federal agents charged him with violating a federal criminal statute, the Gun-Free School Zones Act of 1990. Now, the issue was whether the 1990 Gun-Free School Zones Act, remember, that's the federal one, forbidding individuals from knowingly carrying a gun into a school zone, was unconstitutional because it exceeded the power of Congress to legislate under the Commerce Clause. So remember, the Congress has the ability to regulate economic activity if it crosses state lines, right? But states are supposed to have the power to control things within the bounds of their state, and usually that's criminal acts, right? So, pop quiz, what must an activity touch upon in order for the Interstate Commerce Clause to kick in? Anybody?
Economic.
Good. Economic activity. There has to be some money involved. So ultimately, the possession of a gun in a local school zone, the court ruled, is not an economic activity that might, through repetition elsewhere, have a substantial effect on interstate commerce. So good. Many of you said economic in the chat. Awesome. So the court said, look, there's no money involved. This kid was carrying a gun into a school zone. That's not our purview. And to kind of carry it a step further, remember that argument in Wickard Wheat, the Wickard Wheat case? If there was 1,000 Wickard Wheat farmers and they did the same thing, that would have a substantial effect on interstate commerce. Here, the court, and again, this is 1995, they're saying if 1,000 kids are walking by with a gun around a school, that's not going to affect interstate commerce. Again, 1995. What hasn't happened in 1995, which is kind of crazy to think about? What specific event hadn't happened yet?
Parkland?
Columbine.
Columbine and Parkland?
Yeah, Columbine was the very first. And so this had never happened before. And then Billy said, was this the one who had it in his car and never took it into the school? I don't know if it was in his car, Billy. That's a good question. I don't think it was in his car. I think it was actually on his person. So that's a good question. So I don't want to say specific, like in particular, one way or the other. But at this point, Columbine hadn't happened yet, so none of the studies that are now taken place had occurred yet. That wasn't even a twinkle in our society's eye at this point. So at this time, the Supreme Court looked at this and they said, this is a criminal statute. It has nothing to do with commerce or any sort of economic activity. Now, the court ultimately held that under the theories of the government presents, it's difficult to perceive any limit on federal power, even in areas where states historically have been sovereign. Thus, if we are to accept the government's arguments, we're hard-pressed to posit any activity by an individual that Congress is without power to regulate. So we're starting to see them pull back. congressional power. They're saying, we've gone too far. We're stopping that Marshall-like mentality. We've gotten a little too beefy. We're pulling back and we're giving that power back to Texas. And if they want to do it, then they can, but we're not going to, take over on that at all. Okay. So we're starting to see that Prince, right? And then Ignacio said he had the gun on him. Okay. Thank you. And then Billy said there was a shooting at my school before the mass shooting. Oh, that's awful, Billy. I'm just sorry to hear that. Now, what's interesting, taking it a step further, and that gun ownership near schools was, again, not considered a substantial effect. And they reason that if they allowed regulation on that this would convert it into a police power. Again, you're hearing echoes of Prince in this decision. So the act did not contain any findings of effect from gun ownership, and it was considered unconstitutional. Remember, dual sovereignty. So I want you to kind of see something interesting because there's Stephen's dissent. Remember, there's concurring opinions and dissenting opinions. And Stephen's dissent is, I think, very forward thinking. And it's just fascinating in terms of where we are today in 2026. He argued that Congress could regulate handgun possession under the Commerce Clause because gun violence could have a significant effect on interstate commerce by impairing educational environments, prevent gun violence, empirical evidence of gun violence prohibiting quality education. But he maintained that there wasn't any proof of that as of yet. There were no studies at that time. But of course, as of 2026, there is. When I was working on my PhD at Texas State, I worked with the FBI with ALERT, Advanced Law Enforcement Rapid Response Training, which is now required training of Texas law enforcement. And now there's plenty of studies at this point that would echo that. So it'd be interesting if this went back before the Supreme Court, if they would rule the same. Again, I don't know what they would rule, but now we do have what he is indicating in his dissent. So it's interesting in terms of time. This is 1995 versus today. It's just an interesting, what can change over, a little over, gosh, that's a long time now. All right. Now we move on to Gonzalez versus Reich. Now, Gonzalez versus Reich is all centered around the Compassionate Use Act. Now, as I go through these facts, I want you to keep in your brain Wickard, okay? So I keep on mentioning Wickard, but there's a method to my madness in terms of why. So we have the Compassionate Use Act, 1996. They legalized marijuana for medical use. Now, this is just California at this time, okay? Now, of course, during this time period, this conflicted though with federal law. At the federal level, and up until recently, we have scheduled drugs, Schedule 1, Schedule 2, Schedule 3. Now, up until, again, recently, marijuana was a Schedule 1 drug, meaning it was right up there with heroin, LSD, meth, and again, had very serious ramifications. And so there was a conflict because California is saying, we're going to legalize this at the state level for medical use, even though we know at the federal level, it is considered a Schedule 1 drug. So quite the conflict, to say the least. So we have this young man who is suffering from a medical condition. He is prescribed marijuana by his doctor. The DEA seizes his medical prescribed marijuana from his house. Now, he sues. And the issue was, did the CSA, the Compassionate Use Act, exceed Congress's Commerce Clause power? Do they have the authority to prohibit local cultivation and use of marijuana? Now, do y'all hear Wickard there? Can they regulate a purely local activity that's part of a class of activities with a substantial effect on interstate commerce? Now, think about if that person were to sell their medical marijuana, wouldn't that have a substantial effect on interstate commerce?
Particularly if a lot of people did it.
Yeah, absolutely. Again, you hear Wickard, it's laughing in the background. And so, but there's another issue though that's different even than the Lopez decision. Lopez, again, if we're comparing these different cases, was arguably regulating a non-economic activity falling outside Congress's commerce power. When you look at the dissent in that case, Rehnquist, Sandra Day O'Connor, and Clarence Thomas did something that is really interesting, and you don't see it very often, especially from Sandra Day O'Connor during her time on court, which was they were irate and they were really trying so hard to overturn Wickard here. And it's fascinating that they try to do it with this case. Like, of all the cases that they tried to overturn the Wickard decision, they try to do it with this case, with this case. So they claim that the private cultivation and use of marijuana was a purely local activity that was beyond the scope of federal commerce powers. And O'Connor declared the homegrown cultivation and personal possession and use of marijuana for medicinal purposes has no apparent commercial character. Isn't that funny? For those of you who are familiar with O'Connor, it is just almost very out of character for her to write this. So it's this case, and in particular, this dissent was fascinating. And last but not least, we have the Jacobson decision. So this case in particular is interesting in terms of the time period and what it ultimately ruled. And many of us heard about this case in 2020, of course, because it was referred to quite a bit. But it is the biggest case regarding public health. And it all centered around a citizen who challenged the state's authority to impose mandatory restrictions on personal liberty for public health purposes. Now, during this time period, we have Massachusetts, which it allowed city board at that time. We didn't have the state board. We didn't have the federal board at that time. So we had a Massachusetts statute that allowed a local city board the ability to protect the basic health, safety, welfare of their community. Now, I want to point out something. Almost every city, almost every state will have that type of declaration, meaning they'll protect the city's safety, health, and welfare. You can check out your own. Most of them have that, right? It's a very common phrasing. So with that being said, in 1902, there was smallpox that just scoured the region. And in order to combat it, they required all adults to be vaccinated in order to control it. And if they refuse, they would be fined about $5, which is about $100 today. Now, at that time, Jacobson, he said no. Now, it's important to note that he had a bad reaction to it, and he was afraid that he would have a really bad reaction to it as well as his son. And so he sued, saying, I'm not going to do it, and if you can't make me. And so there was no mechanism to force him to get vaccinated. And they said, look, the worst that can happen is if you don't take it, you have to pay the fine. And he sued, and he said, I don't want to pay the fine. Now Marshall is back. Now, if you hear Marshall, again, what should you instantly think of?
Federal government.
Okay, so anytime you hear any type of Marshall-like decision, you know the federal government's going to win. Now, during this time period, anything that the government did in order to combat things for the health, safety, peace of the people was supported. But they didn't find that it overstepped their authority. Instead, Harlan during this time period said, based on the Marshall mentality, to protect the liberty and health, safety, welfare of the people, they can do that. And that the people do have rights. But it's important to note, just as I know at the beginning of this class, in terms of the Bill of Rights, no right is absolute. And liberty itself is not an absolute right, and each person to be, at all times and in all circumstances, wholly free from restraint. Laws, though, cannot be arbitrary, meaning you can't just make somebody do something that could kill them. That would be cuckoo, right? So they said it shouldn't apply to these two individuals, the father and the son. If it's going to kill them, we can't kill them, right? That would be arbitrary. That would be silliness. So if this vaccination would legitimately potentially kill them, we cannot make them take it, right? But we cannot just not force everybody to do this, right? So unless they have a legitimate purpose for not taking the vaccination, everybody needs to take it. Unless, again, they have a serious concern, a legitimate purpose for not doing it. Because we have a responsibility to protect our people. So that was the preeminent case, as y'all can well understand, that was pointed to again and again and again during 2020, 2021. Now, this last slide I did specifically to help y'all. I hope you guys, as we are going through, have kind of a case cheat sheet. But in case you guys don't, I thought this might help kind of kickstart that. So I put Wickard case, you should be associating with the substantial effects test. Heart of Atlanta case impacted interstate commerce, solicited of out-state travelers. If you're thinking about the Lopez case, they argue that there was no economic activity, thus no commerce to regulate. If you're looking at the Gonzalez case, you should instantly think Congress can regulate marijuana grown for local use because it had an economic flavor. And then last but not least, you have Jacobson, which said the government can mandate vaccines because economic flavor. If everyone is sick and dies, no one can work. So just, take that into consideration. Absolutely. Ignacio said, fun fact, this gun case as well as the red color case on Fridays happened at my high school and alma mater and undergraduate alma mater. Oh my gosh, that is a fun fact. That's crazy. Very, very interesting. All right. So I hope that all helped. And sorry I was kind of wonky today. My dog, who is 20, he's kind of going downhill, and I'm sorry. It threw me off today, so I apologize for kind of being off. I've been trying to like address him, and sorry I was a little off today. I know I was off, so I apologize for that. But nonetheless, I hope those cases made sense. I know interstate commerce can be a lot, but the way you should approach the questions is ask yourself if you have a federal or state actor and if there's an economic flavor. If there's any type of money involved, great. But if there's not, you should ask yourself, is the activity, might it have a substantial effect on interstate commerce? Even if it just happens in one state, it could still affect interstate commerce, just like Wickard wheat, right? And let's see. Billy said the red color was gang related at our school. Oh, wow. That is really interesting. That is really interesting. And Ignacio, did you have a question?
There was a good question in the chat earlier, I think in regards to the Heart of Atlanta motel, and it was I think it was in relation to the case, but it was from Brian. He said he asked, "Does this case change the answer to the private university question on wearing red on Fridays?"
Let's see. Does this case change the answer to the private university question on wearing red on Fridays? And can you walk through that a little bit, Brian, when you ask that? Are you saying the heart
Yeah.
of
Yeah, absolutely. So this is where I get a little bit confused with all of the different cases is the first distinction that you made with the universities was public versus private.
hmm
And the public stuff I'm totally tracking with. I think that makes a lot of sense.
hmm
With the private, it appears that the direction is as a private entity, you can do basically anything you want. You don't have to respect certain rights or not rights based on the way that case was trending, or that example was trending. But then when you look at things like the Heart of Atlanta, where
hmm
that is a private um, business, and yet they were still held accountable by federal rules, which to me would be analogous to the Red on Fridays example is if a public entity needs to abide by that, wouldn't by extension the private entity also need to abide by it based on the precedents that are being set with Heart of Atlanta and similar
Oh, I
types
see
of
what you're
things. So
saying.
I'm trying to understand like where is private still private and that they can do whatever they want to do. What's kind of the litmus test for that? Because
That's,
Basically,
it
where do
still
you draw the
confuses
line,
me.
right?
I'm sorry.
Ignacio, go ahead.
No, I said basically it's almost in the essence like where do you draw the line, right? I
Exactly.
think
Yeah.
Great question. And Dan also there, I see in the chat said no economic impact with red on Fridays. So all great
Well,
question.
yes and no, though, right? Because public or private universities still get federal funds. There's still students from out of state, presumably, right? Like all of those things, you can always find it. The issue with the interstate stuff is you can always find an interstate connection, as you said earlier, right?
That's
Everything happens.
exactly right. So, and that's the controversy, and I
Yeah,
want to highlight that therein lies kind of the big controversy is Ignacio just said, "Where's the line?" That's the million-dollar question: is where is the line? Because it's not just federal actors, it's state actors, and Texas A&M would fall under that because we have a whole bunch of state money that comes in as
yeah.
well. We have the public state fund that comes in as per the Texas state constitution. We got a lot of funds from that. But private action prevents, like our good friend Rolston, right? Morton Rolston, him from preventing discrimination into his business because he is engaging in business that affects interstate commerce, right?
Right.
So that's where the hat plugs in on his activity and he can be regulated.
Yes.
Now, take it into A&M. Because we wear two hats, we have the federal hat and we have the state hat, we can be regulated.
Right.
So the line gets further and further and further and further. And kind of like what I indicated earlier, with just looking around where you are right now. And is anything around you made within your state and just purely within your state or even within your town? And I'd be willing to bet that pretty much nothing is. And so that has been kind of the argument by a lot of people is where is the line? And I'm not saying it's a good or bad thing because I don't
Right.
have an opinion on it, but there is a lot of regulatory room based on the fact that pretty much everything, comes from out of state. And so there really is the ability of the government to regulate, a lot.
So going back to the first example then with the private university with Red on Fridays
Mhm.
or private school, how come they can do it?
Well, if it's a religious institution like St. Mary's, because St.
Yeah.
Mary's is religious, that puts them into a separate bubble. So they are able to insulate themselves based on the fact that they are a religious institution. And so they are able to establish, based on the exercise clause, the free exercise clause, they
Right.
can exercise their religious principles the way they see fit. So if they say to their students, everybody wear crosses on Monday through Friday, they can do that because that's the way that they want to exercise their religious beliefs. So that's a First Amendment religious bubble that separates them from the government being able to tell them how to exercise their institutional practices.
Okay. What about just if it's a private entity, no religion?
It depends on the
Where
activity.
is it? Okay.
So if it's, let's say if Dr. Shaw has a uh, bookstore and I'm just trying to think of an example. If I just want to sell books about coffee and I'm just trying to
Yeah.
spitball here. And I say anybody who tries to bring in any type of other book or request any other type of book is not permitted in my store. I would be allowed to do that. I would be allowed to kick anybody out that tries to, tell me that I have to, I don't know.
So that's like a private club.
Yeah, almost.
Except if but then it extends like, what if they are of a different race that you don't approve of?
Oh, then
Then you
it's a little
can't kick them
trickier.
out.
Correct. And
Yeah.
then the 14th Amendment kicks in. If they're a
Okay.
protected class, they have to be a protected class. If they're not a protected class, then, I can kick their booties out. But if they are a protected class, then I cannot. And we will get into that this next week.
Okay. Okay. Great. Thank you.
Yeah, absolutely. And Billy said punishment unless. And then Carla said, but why wouldn't the Commerce Clause come into play then for private institutions? I understand Congress has limits on private institutions, but if they receive federal funding, why are the limits valid? Well, it depends on if they do get federal funding, Carla. I mean, the answer, and I hate to say it depends, but it really just depends. Because I can't categorically say, yes, they can be regulated. It depends on what are they being regulated about, and do they receive federal funds? And if they do receive federal funds, what type of regulation are we talking about? Again, it would be improper to say categorically, yes, they can be regulated, and we need to be a little bit more specific in terms of what type of regulation we're talking about. Does that make sense? Because of course, Paige said yes and no. That's it. Well, good. You're getting into the lawyerly spirit. I like that. Yeah, I mean, it's in law, we can never say categorically yes or categorically no, because there's always exceptions. Just like in terms of the First Amendment, we're hearing a lot about, yes, they have a First Amendment right. The answer is perhaps. Or Second Amendment. He doesn't have a Second Amendment right, or he does have a Second Amendment right. The answer is perhaps, right? It's the never purely yes, it's never purely no. There's no Bill of Rights that is absolute. There's always exceptions. So yes, and Dan said, in my military life, everything it depends. And that is absolutely right in terms of the Bill of Rights. Again, nothing is absolute. Just like the perfect example is fighting words. You have an absolute right. I mean, I'm sorry, you do not have an absolute right to stand in front of a crowd of people and say, and I'll give you an example. If I were to stand in front of the class and say, let's say they change the parking fees to $5,000 a semester, I would suspect that many students would be quite, upset. And so I would stand in front of the crowd of people and I would say, everybody, let's protest, let's walk down the street and, with signs, and we're going to protest this increase in fees, screw them. That's 100% okay. That's protected. Nothing wrong with that. However, it would be very different if I were to stand in front of the crowd of people and say, let's burn this mother down, right? It's very different. Why? Because those are considered fighting words. And the way that's legally defined is if I am making an imminent threat, meaning I'm making an immediate threat of imminent violence, meaning just by the utterance of my words, something imminent, immediate will happen. Not might, will. And that's kind of the test is it's not maybe, but will, right? And so again, there are exceptions and there are categorical carve-outs to protections. And so you have to dissect these words in order to determine, is it protected? Or in terms of the Interstate Commerce Clause, is it economic? Is it activity? Is it within the state or is it out of the state? And if it is in the state, could it have a substantial effect on interstate activity? All these things have to be dissected. Just like a scientist dissects a specimen, you guys legally are having to dissect these hypotheticals to determine if they fall into these categories. So again, I said it last week and it sounded rough, and I didn't mean for it to sound rough, but ultimately we don't care what your conclusion is. What we care about is, how did you get there? What case law did you use? And hopefully you use case law to support your answers. And did you use it in a way that makes sense, right? So hopefully that made sense. Okay, so
Yeah.
oh, I'm sorry,
Sorry.
go ahead.
No, I was just gonna say, as far as the St. Mary's case is concerned, if the what someone said in the chat that the color red was associated with gangs
Hmm.
affiliation. That would make sense to me because, again, having gone there, they didn't discriminate against other religions. There was people of with the Sikh background, they would wear the ceremonial head covering and carry the ceremonial knife. That was okay, but so that was allowed. But if someone, again, if they try to figure out what was the reason for wearing color red, and it was not something that was protected as far as religion, then that's where they had a problem with it. And then the way that they did impose their religious belief was forcing you to take 6 hours of religion classes and 12 hours of philosophy. And that
Oh,
was basically it.
yeah, that's a perfect. Thank you for sharing that. That's a great illustration of establishment clause in action, establishment and exercise. And Billy said protected class can be kicked out if they disturb the peace. Yeah, that's a great, thank you, Billy. And that's a great example too. So there's exceptions to every right has an exception. So very, very good. All right, guys. Well, thank you for letting me go so over today. I'm sorry I did go so over today. I didn't realize you guys let me, I just rattled on and on today. So I apologize for that. But thank you so much and great questions. If you guys have any more questions, feel free to reach out. And yeah, I know Dr. Helgi's really looking forward to your submissions this week. And I promise I'll be done grading your submissions from week 2, hopefully by today. And I'll give you plenty of feedback, like always. And I'll upload the recording and the PowerPoint and all that fun stuff here shortly. And that's it. Oh, thank you. I appreciate that. Can I call you? And yes, absolutely. If you can call me right now, that'd be great. Or I can just stay on the call here if you prefer. Absolutely.
Thank you.
Bye. And yeah, I'll just stay on this Zoom call if that's okay, and that way we can just continue chatting as people get off.
Okay. So I'm not sure if everybody's off yet or not.
Let's see. Hold on. I think I can. Hold on.
Slowly but surely.
Hold on. Doop. And then hold on. I can remove. Because some people might have walked away. Hold on. Remove. And almost. Move. And I think it's just you and me, but let me double check.
Okay.
Show participants. Yes, it is just you and me.
Okay. All right. Hi, Dr. Shaw. How you doing?
I'm good. How are you?
I'm doing well. I'm at work, so if you hear any people in the background, it's just because they're working. So
No, you're fine. You're fine.
okay. I had wanted to ask you because I had replied to your note on the assignment that you graded for yesterday, and I had mentioned that I had some internet issues, so it was saying that I didn't reply to my second person, but I did. I saw it posted. At least I thought it posted, but then I guess it didn't post. And
Oh,
we had the issue with the weather and stuff, so my internet was a little iffy, and I thought I replied to the second person, but I guess it didn't. So I was just trying to see like what could I do to like fix that, and I didn't want to like post it after 12 or after the
oh
time
no, you're
frame.
fine. You're fine. I'm not. So if you want, because I know the internet and everything was so crazy this last weekend. So if you want, just go ahead and post it again, or like post, and I'll
Okay.
go back and regrade.
Okay.
So yeah, not a problem at all. So thank you
Okay.
for telling me, and because I'm not done grading, so I can easily
Okay.
go back. And if you can, just after you do it, just shoot me an email and just say,
Okay.
you don't have to rush. Like there's no rush whatsoever because I know you're at
Okay.
work. So even if it's tonight, like don't like you don't have to get on there right now. Um,
Okay.
so take your time and whenever you are able to tackle it, just shoot me an email and say I went ahead and did it and blah blah blah, and then you're gonna be good.
Okay, beautiful. Okay, thank you so much.
Yeah, absolutely. Yeah, technology's been funky lately. I don't know what's going on.
All right. Well, I appreciate it and thank you. You have a great day.
You too. Bye.
Bye.